Welcome, everybody. My name is Jeff Fowler. I'm the president of the Apartment Owners Association. It is great to see you today. Thank you for joining us, and you're in for a treat with our speaker today. So much experience, expert on the topic of evictions, and he will be able to answer some of your questions at the end. And just want to let you know that we have these live streams all the time. And last week we covered ADA compliance. A guy with 35 years experience came in and gave us his 4 proven steps and just taught us a whole lot. You'll learn so much, so go back and view that one. Right after this one at 1 o'clock, we do have another video, another live stream, and it's how to get the most from your insurance claims. And so you'll want to just have that one in your back pocket. You just want to know these things so that when something happens, then you are prepared to act with all the knowledge, all the resources that you need. And that's what we're here for. AOA, one of the largest individually organized groups of apartment owners in the state. And we are here for you. We want to keep you in the know. We want to give you the information that you need so that you can make more or save more, and so that the process of providing housing is easier and more enjoyable for you, because we know that the process should be fun, and we know that through the process you're providing for yourself a retirement and leaving a legacy, and that's what we're all about. And one thing that I want to highlight today, AOA, we have a lot of different benefits, but one of those things is the property management software. It is not free. You pay a monthly subscription for it, but it does a lot of things. It automates a lot of your flows. There's a work order system, there's a tenant portal, online rental payments, online rental application, and there's a way to get that information into your AOA membership account to run the tenant screening. Anyway, so I highly suggest getting on that to maximize your AOA membership. If you're not a member, we have a guarantee for you. 1 whole year, you can get your money back if you don't like the service. So please join AOA if you haven't. Renew that membership. And anyway, we're going to get started here. And our speaker today, he's been in business for 44 years. He just doesn't seem that old. And he has he's done over 200,000 evictions. And he's evicted everything from people to boats out of the harbor. And so lots and lots of experience, lots of fun stories, and he is the founder and the president of Dennis Block and Associates. It's my pleasure to introduce to you today Dennis Block. Thanks, Dennis.
Welcome, everybody. And Jeff, thank you for that nice intro. I appreciate that. The Apartment Owners Association is the premier apartment association for the state of California, and I do recommend everybody joining. It's so nominal, the fees and the benefits that you get, including getting to call my office and asking us as a member any questions. You'll get to talk to an attorney. As Jeff has said, I've been in business now. Actually, Jeff, it's been 45 years, not 44. You missed a year. And we're up to about 20 attorneys. I know I've been doing this for so long that two of those attorneys are actually my children, 2 of the 20 that are fighting it out in court as we speak today. We're going to be talking about, obviously, the latest extension of the Tenant Relief Act. That's AB 382, or excuse me, AB 832, if you're counting numbers. It started off as AB 3088, then got extended by SB 91, and now we're into AB 832. I mean, you have to be a mathematician to understand what's going on in the landlord-tenant realm. Basically, I'm going to briefly, because I have done this in previous webinars, go over what the aspects of the Tenant Relief Act are and how it affects landlords. In addition, We're going to do a little bit in terms of statewide rent control and explaining some of the characteristics of that provision of the law and how it interacts with the Tenant Relief Act. But I do want to start with some, if I could call it this, some good news. And what's the good news? The latest extension of the Tenant Relief Act is going to end on September 30th. And where in the past, people always said, well, that's just the date that they gave now, and of course, it's going to be extended beyond September 30th. I can tell you with a lot of confidence that it will end September 30th. So what does that mean to landlords? Well, at least as to October 1st, 2021, every tenant is going to need to pay you the rent in full. What a novel concept that our legislature has created. But at least as to October 1st, 2021, tenants will have to pay their rent in full. If they don't, then on October 2nd, 2021, you can serve a standard 3-day notice. Remember those? A standard 3-day notice to pay rent or quit. And if the tenant doesn't pay the October's rent within the 3 days, we have the right to go forward with a standard eviction case to evict that tenant. So that's the only good news on the horizon here, that we're about a month and a half away from actually serving on tenants a standard 3-day notice for any tenant who doesn't pay the rent at that time. Also, for cases that are not subject to any rent control, like a single-family home, of course, we'll be able to serve a standard notice to vacate on tenants that are in possession of our properties. Let's go back to the start of this, which is AB 3088, the Tenant Relief Act. Let's go over the terms of that, because it really still affects us even after October 1st, because based on the extensions of the Tenant Relief Act, the government for the state of California has sanctioned tenants not to pay rent for 20 months. 20 months, ladies and gentlemen, spanning from a period of March 1st, 2020 through September 30th, 2021. So for 20 months, this wonderful state government has sanctioned tenants without showing any proof of a need or that it's related in any way to the pandemic, but they have sanctioned tenants just not to pay the rent. And of course, my position has always been that I would say, certainly at this point in time, with unemployment under 6%, that at least 85% of the tenants who are failing to pay the rent now clearly could pay the rent. I have a case currently going where a tenant sold his house and netted $400,000 in profit. That went right into his bank account. He leased my client's house. And since April of 2020, he has only been paying 50% of the rent, even though clearly he has the wherewithal to pay the rent. The money's sitting in his bank account. So my position and what I'm seeing is at least 85% of the tenants who are currently not paying the rent are doing so because they're gaming the system, that they certainly could pay the rent if they want to, but based on the way this law is written, where no proof needs to be shown, that they are taking advantage of that which our politicians have allowed them to do. The door is open and they're just merely walking through. There is not a week that doesn't go by in my office where at least 4 to 5 clients have told me that either the tenant who hasn't paid the rent has shown up with a brand new car, or some clients in other cases have seen on social media that their tenants who aren't paying the rent are taking beautiful vacations in nice tropical climates. So again, we're just seeing such an abuse by tenants in this situation, but there will be a day of reckoning, and that will come as of October 1st, 2021, when at least that month's rent will be owed. I call it the politicians have called it the Tenant Relief Act. The truth of the matter is the Tenant Relief Act should be just called a governmental assault on income property owners. The basic rights of our country, what this country was founded upon, is property rights, and that's certainly been thrown out the window. There has been no segment of society during this pandemic that has been forced to support another segment of society except for income property owners. Nowhere in our country has there been one industry forced to support another group of people except for income property owners. Again, who could be a doctor or a lawyer or a storekeeper where you're forced to sell your goods or services and not collect for 20 months. And please don't think that at the end of that 20-month period that landlords are going to be able to see the money that has been, quote, deferred for this period of time. There really is no deferment. This will be 85% again of landlords who have not received their rent will never receive their rent for this period of time. So that's basically what income property owners are faced with. There has been just a new lawsuit filed, a class action lawsuit filed, which we're hoping will have teeth. I'm predicting maybe a 50-50 chance that the lawsuit against the government will be successful. But whatever it is, we have to hold on and we have to take advantage of those aspects that we can at this point in time. So let's go over the so-called Tenant Relief Act, what it stands for, what are the provisions with it. Number one, I'll tell you what it doesn't do. The Tenant Relief Act doesn't prevent landlords from filing certain types of unlawful detainer actions. Our firm is doing so many evictions at this point in time, even though most people think that, gee, the Tenant Relief Act, I can't file anything. That is not true. This week alone, I've had 20 lockouts scheduled for this week by the sheriff's office, which means that I've already obtained judgments, already got a writ of possession, and I've already delivered that to the sheriff, and we already have 20 lockouts just for this week alone. So we are doing evictions, maybe not the type of evictions that we would be first to bring forth, but there are certain types of evictions that we can. For example, if under the new law, we have to serve a 15-day notice to pay rent or quit with a bunch of other documents, which I'll go into. But if the tenant doesn't comply with that 15-day notice, and I'll go into what it means to comply, we can bring forth a lawsuit based on non-payment of rent. Right now, today. If a tenant violates another term of his rental agreement, for example, you've noticed that the tenant has changed the locks. Well, that's a violation of a written rental agreement. It says no alterations to the premises. That's considered an alteration. So if the tenant has violated any term of his rental agreement, we have the right to go forward with an eviction. Maybe they're parking an unauthorized car on the property, maybe an inoperable car on the property. Maybe they have extra people living there that they shouldn't have. Maybe they have pets that they shouldn't have. These are all cases that we have brought at this point in time. Sometimes you have it where your tenant will vacate the premises. Well, that sounds good at first blush, but he leaves a stranger in possession. Well, in that case, we can go forward with an eviction. There's other types of cases where the tenant is creating a nuisance. He's bothering other tenants. Those are cases that we can bring forth right now, today, and which we've been successful in prosecuting and getting a judgment for them. So don't be dissuaded that no eviction case can be brought until this point in time, and we have to wait until at least October 1st. Eviction cases can be brought forth right now, assuming you have the correct set of facts. And of course, calling our office will tell you that, quite frankly, you have no case, and call me back, or we'll tell you that you do have a case, and we'll go over the parameters and what you can expect for that type of case. Going further into the Tenant Relief Act, we have to, how are you ever going to get your money for this 20 months? Well, the politicians say that it's just deferred rent and that you'll definitely be able to get it. Well, let's go into what the aspects are, how you're going to get all this missing rent for this period of time. There's two time periods that you have to be aware of. One is called the protected time period. The other time period is called the transition time period. Let's talk the protected time period first. That's all the rent that was owed from March 1st, 2020 through August 31st, 2020. For that time period, that's considered protected time rent. And at that point, the legislature has declared that the tenant doesn't owe you rent anymore for that period of time. No more. What they've done is they've changed the name rent, and they call it now a civil debt. So you have the right to seek money from your tenant, but it has to be in the form of, this debt is now a civil debt, it's not rent. So why did the legislature change the name from rent to civil debt? Very simple, because that period of time, once again, from March 1st, 2020 through August 31st, 2020, is a period of time where that is not considered rent. It's considered a civil debt. And the reason they changed the name is because that can never be the subject of an unlawful detainer. So you can never walk over with a 15-day notice to pay rent or quit, or a 3-day notice to pay rent or quit, and then bring forth an eviction. So if you can't bring forth an eviction, what can you do for that period of time? I mean, hell, the guy owes me for all those months. Well, what you can do is you can bring forth a civil lawsuit. When can you bring that civil lawsuit? Well, the tenant owes you that money, it's deferred, until October 1st, 2021. October 1st, 2021, coming up in about, a month and 18 days from today. If the tenant doesn't pay that rent, again, that's the protected time period, you have the right to bring forth a regular civil lawsuit come November 1st, 2021. So if you don't get your rent for that time period as of October 1st, you wait till November 1st and you can bring forth a regular civil lawsuit, hire a law firm to do that for you, or you can go to small claims court. Small claims court has a jurisdictional limit for $10,000, but for this civil debt, it's unlimited. So I have so many clients where this tenant owes me $15,000, this tenant owes me $20,000, this tenant owes me $25,000. In the case that I talked about where the guy had $400,000 in his bank account, my client is owed currently $40,000. That's just one unit. It is a single family home, but that's just one unit. The debt is staggering to my clients. One client, a notable person who owns a lot of property in Los Angeles, the debt owed to him is $1.2 million, where rent is owed, and they're using this excuse. So you are going to be able to go forward as of November 1st and file a case in small claims court. In October, we're going to be starting a program in my firm where we will file the paperwork for you because they don't allow attorneys in small claims court. We'll do some skip tracing to find out where your tenant is, if they have moved away, and take care of the serving. But you can check with us in October for that program where we'll be filing our assisting landlords with small claims court. So it'll be pretty nominal to at least attempt to get a judgment. But the politicians, of course, say that, hey, you're going to get your money, it's deferred. Well, the truth of the matter is, I don't think you will. I think 85% of the landlords will either not attempt to collect or will have no basis because Maybe the tenant moved to Idaho or moves to some location that you can't find, so there's no way to obtain a judgment. And if you do obtain a judgment, are all judgments collectible? I mean, you got a judgment against this guy. Obviously, this person has to pay you now. Well, that's not the case. A lot of judgments go uncollected. The person has no assets, so there's no way to attach a bank account, or there's no way to garnish wages. So the debt is just going to be lost. This is a debt that is going to be lost income, that is sanctioned by the California Legislature and our wonderful governor, who definitely needs to be recalled. Please jump on that bandwagon in terms of that recall when your ballot arrives, please. Okay, so we talked about the protected time period. Let's move on to the transition time period. That's the period from September 1st, 2020 through September 30th, 2021. That's 13 months, considered the transition time period. Now, for that period of time, the tenant is required to pay 25% of the amount owed for that period of time. So when does he have to pay it? Every month? Well, of course, that would be logical. Okay, it's August. Let's pay my 25. I'm only asking for 25% of the rent. But the state legislature did not say that it had to be paid monthly. What they said was that it had to be paid by September 30th. September 30th. And if it's not, then you can almost file an unlawful detainer for that rent that's owed for that period of time. I say almost for that period of time. And I'm going to get into that in a second. When we talk about that 25% of the rent is owed for the period of September 1st, 2020 through September 30th, 2021, that 13-month period, well, what happens to the other 75%? Where did that money go? Just fly out the window? The answer is yeah. The legislature's made it fly out the window. Well, how did they do that? Well, as to the 75%, just like the protected time period, that's considered a civil debt. So it'll never be the subject of an unlawful detainer action. Can never be the subject of an unlawful detainer action. And that means, again, you can file a small claims court lawsuit or a civil lawsuit as of November 1st, 2021. So during the protected time period, that's all a civil debt. As to the transition time period, that's considered a civil debt as to 75%. Can never be the subject of an unlawful detainer, and you have to sue for your money come November 1st and pray that you get a judgment, and then pray one more time that you can collect on that judgment, because otherwise, what is it? It's lost rent to the landlord, and I mean lost rent to the landlord that will never be recouped. Now, let's go back to the 25% that was owed by the transition time period, again, from September 1st, 2020 through September 30th, 2021. I told you that the tenant didn't have to pay it monthly, the 25%. And I told you it was due on September 30th, 2021. And if they don't pay it by the September 30th, 2021, then you can immediately file an unlawful detainer, correct? Correct? And the answer is no. There's another requirement. This might be a good requirement, but in all likelihood, it'll just be another boondoggle and a waste of time. Before you can file an eviction based on based on 25% of the rent that was owed as of September 30th for that transition time period, you got to do one more thing, ladies and gentlemen. You got to go to a website. The website is called housingiskey.org. Housing.com. And you can do that right now, by the way. Housing is ISKEY.com. And you have to apply for the rent for that period of time, for the transition time period and also for the protected time period. And according to the governmental program, they are assuming the tenant joins in and assuming the tenant qualifies, the landlord is entitled to get 100% of his rent. Landlords have been applying for this. I've seen in a very small percentage of cases that landlords have actually gotten their money. If you've already applied for the current program, which was 80%, the way the program works now is that the additional 25% allegedly will be given to you without any further application. If you've never filed an application, do so now, and maybe the state will reimburse you 100% of all the rent that was owed. But again, that does require the cooperation of the tenant. We find that to be spotty at best. It does require that the tenant qualify, and that's really where the rub is. In many cases, in fact, in most of the cases, the tenant just doesn't qualify. So on that basis, the landlord will get nothing. So the landlord has to apply and then either get denied or at least another 20 days has to go by where the state has not given any decision whatsoever. At that point, no decision or a denial, the landlord then finally, after September 30th, can go forward with an eviction case for that rent that was owed during the 25% of the rent that was owed during that transition time period. Pretty confusing stuff, huh, ladies and gentlemen? But that's, of course, what we're faced with based on the newest extension. So why do I say that this is going to be over as of September 30th? And I'm saying that with certainty? Well, of course, I've predicted that it would be over many times before that, but I'm really certain this time, and that's because the government is now making you apply for the Rent Relief Act, where allegedly you have a chance of getting 100% of your rent reimbursed by the state through a federal program. Right now, I know the city of Los Angeles, for those persons that have property in the city of Los Angeles, that program, I don't know, is not open yet. I don't understand why, but it's not open yet, but check back in a week or so. Everything I said about the state Tenant Relief Act doesn't apply, by the way, to the city of Los Angeles. They have their own statute which takes precedent over the state statute. Briefly for the city of Los Angeles, because there are a lot of viewers who have property in the city of Los Angeles. In that situation, all rent is deferred for 1 year until the mayor of the city of Los Angeles. Isn't he gone yet? Isn't he supposed to be in India by now? I guess he's still sticking around. Anyway, we have to wait for the mayor of the city of Los Angeles to declare that the emergency is over. Then at that point in time, the tenant will owe the next month's rent. All the other rent is deferred for 1 year. Of course, you can go forward with the housingiskey.com to see if you can qualify. But again, the LA program is down. But as to all the other locations, what I was talking about with regard to the transition time period and the protected time period, and applying for that and then potentially suing people on November 1st in small claims court and bringing forth unlawful detainer actions for non-payment of rent, either owed for October 1st rent or for the 25% of the rent that was owed during the transition period. So that's basically the parameters of dealing with the Tenant Relief Act. Remember, this is really a governmental assault on income property owners. I'm going to open it up now to questions. Jeff, take it easy on the old man, but I'll stay here as long as I can to answer as many questions as possible.
Great. All right. Well, we want you to have time to get those questions in. So if you're on the AOAUSA.com website, there's the blue help button, and you can press on that and then type in your question, and that'll get your question to us. And again, Facebook, YouTube, type in the chat. All those questions are going to be funneled down to me, and I'll ask those questions. But before we get started, I do want to mention that there are different opinions about will things be extended or not. And at AOA, we are not so certain that this is going to actually end on September 30th. And so preemptively, we believe that we need to be writing the mayor, the governor, your city council members. We believe that that's what we should be doing now. And so we have a protest going on, and it's been amazing. You guys are amazing. We've been polling the members that call in. Hey, have you been able to send the letter to your city council members with that picture? The picture's really worth 1,000 words, and it's been an incredible turnout. We've had 40% of the people of all of you that call in said yes, I sent that off already. And a good portion of the others said, well, you know what, I haven't done it yet, but I'm going to get to it. And so I just want to encourage you to get to it and do it. And let's make certain that this thing doesn't keep extending and extending and extending, because they have lots of good excuses. You have, Thanksgiving's coming up, and then it's Christmas, and so we can't evict anybody. It's going to be cold. And then, been distributed for this rent relief program, so we just need to continue to push this thing out, and that is one of the things that they're going to do. They're going to keep coming back and saying, well, the funds haven't been distributed yet. Some of these programs, you wonder why they're dysfunctional. Is it dysfunctional because they're incompetent, or is it dysfunctional because they just want to keep extending this thing? And if it was like PPP and everybody just got the money and they took care of the documentation later, that would have been so much better. But we have a mess. It's a real mess, and that's going to be one of the reasons why they want to extend it, one of the talking points that they have. And so really, please go to the AOA website, and we're going to put that up for you, AOAUSA.com and /protest. And if you go to that, you'll see what you'll want to do is definitely go to that page first, download everything that we have there. There's an image, there's a letter, there's a place for you to put in stuff, and send that in the mail. It's so easy to delete, but it's a lot harder when you get something in the mail and it's stacking up, and literally you guys are making it stack up. So stack it up with your city council people, send that off, and so go ahead and do that, and then just Google your town. So let's say you live in San Francisco, and then city council members, and you'll get addresses for them. Google California Assembly members, and then that'll come up, and you'll be able to type in your zip code, and you'll see exactly who represents you and who you can send these pictures to. Again, a picture really is worth 1,000 words. We believe that it will be effective, and so we're asking you to participate with us. Freedom is a beautiful thing, but freedom is lost if you don't exercise it. So this is one of your freedoms. It's a right that you have, and we need to fight for the property rights and for the whole industry. So whether you've been impacted or not, we want to encourage you to do this. And we have Jeffrey Palmer. We had his $100 million lawsuit. That's something that we're hoping goes really well for him. And then Dennis Blocky mentioned a class action lawsuit. I'd like to hear more about that from you, Dennis, here in a minute. And anyway, so that's the political action piece, very important. So I wanted to share that with you. And then right now we also do have one other little thing that we're going to do. And again, this is just kind of a little break for people to get the questions in. We're not going to be able to get to everything most likely, but we're going to go for it. We have a wheel and a prize wheel. So everybody that registered for this event, you're on the prize wheel. And what we're going to do here is pick one name, and we're going to roll that thing. And we're going to pick one name, and that person is going to win a 1-year subscription of the AOA Digital Property Manager Cloud. And so let's see, who do we have? All right, Patricia Bew, you have won. Congratulations. We will get that to you and share with you how you can get that free subscription. And now we will go to questions. Thank you for being patient with us, and we're going to get to it. So here we go on Facebook. Janae, when can we post approved capital improvement rent increases in Los Angeles? Dennis.
That's a good question, and without a true answer. Under the City of Los Angeles Rent Stabilization Ordinance, you are entitled to apply for a capital improvement increase in the tenant's rent. And by doing a major improvement, you're submitting certain proof to the city, and thereby, like you're doing a new roof or major plumbing or electrical work, and technically you're supposed to be reimbursed 50% amortized over a 5-year period. And then the city will allow for a rent increase. I think it's around $35, $36 maximum per month that you can then distribute to the tenant and require them to pay it. The problem with that is that under the emergency law, the mayor of the city of Los Angeles has forbidden any rent increases until 1 year after the mayor declares that the emergency is over. So the issue would be, here you have the city authorizing the landlord to increase the rent based on a capital improvement, but then you have juxtaposed against the mayor's emergency order that says no rent increase. My position would be that if you tried to increase the rent, they would merely quote the emergency order, and on that basis, you would not be allowed to ask for that increase at this point in time. So even though, quote, it's a capital improvement increase, it is an increase. It's a rent increase any way you look at it. And I think at this point in time, most courts would hold that you cannot do it.
Great, thank you. And then here's Marguerite on YouTube. Why should we not have a 12-month lease? What benefits are there to not having a 12-month lease?
There's a lot of benefits if you're in a area where your property is subject to statewide rent control. Under statewide rent control, you do need to have good cause to evict if the tenant has occupied the property longer than 1 year. So if I have a 1-year lease, and let's pretend, the guy he's just not a nice person, and you just don't want to continue on with the lease. Well, if he's on a month-to-month lease, or a 6-month lease, or even a 9-month lease, once that lease is over, you can either say, I'm not renewing the lease, or you could issue a 30-day notice to vacate. But once he's there for 1 year under statewide rent control, you need good cause to evict. Now, there are some ways to evict based on good cause, but if you don't have anything, now you're stuck with this person. So if your property is subject to statewide rent control, my suggestion is never give a 1-year lease. Give a 9-month lease, give a 6-month lease, or just do a month-to-month tenancy. This way, you'll have 1 year to determine whether you like this person or not. And if the relationship just doesn't seem to work for you, you'd be able to easily terminate that tenancy.
Great. And that's a good question. Gretchen Watts on YouTube. How should we screen new tenants?
Well, the first thing is you have them fill out an application form you can get from the Apartment Owners Association. Go through that application, call the employer, making sure that he does work where he works, call any of the references, call the previous landlords, which name and address and phone number should be listed. The next most important thing to do is to run a credit check through the Apartment Owners Association. You want to see the credit worthiness of this person. You also want to do an eviction check through the association, which will tell you if the person's been evicted in many cases. And you also want to do a criminal background check. I mean, God knows you don't need to have, felons in your building if it's going to affect other tenants. So those are the initial things that you should do in terms of screening your tenant.
Right.
Other things that you can do even before the application is to ask them how many people are going to be moving in. Do a telephone interview with the person. How many people are going to be moving in? How much money do you make? Because we have a certain criteria that you have to earn at least 3 times the monthly rent or whatever your criteria is. So I would start the interview right from the phone call before you even proffer the application to your tenant. But once he's qualified in that respect, and he's not going to bring in, 29 people into your 2-bedroom apartment. He's going to bring in the correct amount of people. Then have him go through the application and certainly do a credit check through the Apartment Owners Association. It's the best money you'll ever spend, because if you don't do that, we see it where tenants get in the first month, pay the initial security deposit and the first month's rent, and then magically are claiming all kinds of things. And this could have been taken care of if you had done proper screening to your tenant.
All right, thank you, Dennis. Now, one thing that I do want to mention we have the double whammy eviction search, and so basically it's a double whammy because there's 2 different multi-data-based places where we go to. We get it from 2 different sources. And so it shows a lot more. Everyone misses something, so we're hoping to show more. But it also has the civil judgments in there. What if there's a civil judgment for this debt that's owed from a COVID protected period? Are they able to not take the applicant based on debt that they have from the COVID protected period?
Well, if you think about it, the tenant doesn't owe money for that COVID period. It's been deferred. So, and the statute is clear that you can't use that as a grounds not to accept that tenant. Again, really, it's kind of like people where they have a co-signer on the lease, and I'll get this question from my client, where the tenant's claiming COVID, not paying the rent. Maybe in the city of Los Angeles, where it's going to be deferred now for 1 year until the mayor declares that it's over. Can we go after the co-signer? Well, you can go after a co-signer where there's a breach of the rental agreement. Well, not paying the rent would seem like a breach of the rental agreement, but is it? If the tenant doesn't owe you the money, then there's no breach of the rental agreement. In other words, our government has rewritten your contract, where it doesn't have to be paid now. So therefore, there's no basis of going after the co-signer. And of course, there's no basis of rejecting the applicant on the basis that he didn't pay rent during this COVID time period.
All right, John Brown on YouTube. I gave a tenant a 15-day notice back in July. They have now failed to pay both July and August rent. In addition, they have a separate lease for a garage. Can the 15 days still be enforced? Sorry.
Well, first of all, did the writer say what city the property was located in?
No, they did not.
Okay, always try to do that, ladies and gentlemen, because that can affect it. I mean, let's pretend that you're not in the city of Los Angeles, so you're under basically another jurisdiction, so you can enforce that 15-day notice. But what does that mean? It means that the tenant has to pay at least 25%. I'm assuming this is the transition period from September 1st through September 30th, 2021 for that 13 months. He has to pay 25% come September 30th. If he doesn't, then the landlord now, and you should be doing it now anyways, should apply under the Rent Relief Act to see if the government's going to pay you the money. By the way, Dan Fowler corrected me during a little timeout, and what he said to me was, it's not the government that's paying us this 100% of the rent, it's our money. And he's 100% correct. It's our money, it's our tax dollars that are basically reimbursing income property owners based on the crazy rules that were enacted by our California legislators and our governor. But you're going to first have to apply for that rent relief, and if you're either turned down or there's no decision within 20 days, then of course you can proceed forward with your unlawful detainer action based on that 15-day notice.
Great. Okay. So if you get that, everybody, make sure you put what city you're in, because those specifics.
And what type of property as well.
And what type of property.
Like
how
an
many
apartment
units,
house or a house.
How many units, because all that makes a difference. What is the current status of the 100% rent back to the landlords? Sephora on YouTube.
Well, that program has been enacted. I haven't heard of anybody who's gotten the 100%. I'm sure that there have been some. I'm not sure what the requirements are because they haven't really published the full details that I'm aware of. But assuming your tenant participates after you've applied, and assuming your tenant qualifies, then technically under the statute, you're entitled to 100% of that lost rent. Why a tenant would not participate in that program, God only knows, because it is a debt. It will still be owed by that tenant. And if the tenant can get basically a year's worth of rent for free, why wouldn't they take advantage of that? But again, we deal with a lot of different people. So we encourage landlords to apply for the program, see if you can get your rent. But I haven't heard anybody at this point in time, based on this new program, that has received 1 penny.
Okay, yeah, and I do know someone who has a significant number of units, and they have been receiving it. So I know that it's happening for some people, but not happening for everybody. All right, Christopher on YouTube. If a tenant refuses to pay their 25%, can they still be evicted?
Yes, absolutely. As I just stated, after you apply for the rent relief program and are either turned down or a decision is not made within the first 20 days, you have the right to then proceed forward with an eviction based on that 25%.
Great, and it's housingiskey.com. You go there, you apply there. Hopefully the tenant participates in it. But the big thing there, isn't it, they need to be 80% of median income. Is that correct?
That's how it was on the original tenant relief, rent relief program. It was 80% of the median income for the county upon which the tenant lived. I'm not sure that requirement is in the current giveaway rent relief program. If it is, it's certainly going to cut down because most people are not earning less than 80%.
Right. I mean, you just cut off 60% of all the tenants right there.
Mm-hmm.
All right, Stephen on YouTube. LAHD 4-unit building in Los Angeles. Is there still a moratorium on the annual 3% rent increase? Okay, yeah, we asked that question already, but I'll let you answer it.
Very quickly, the answer is there is no rent increases for rent-controlled property in the city of Los Angeles. You will have to wait for the mayor of the city of Los Angeles to declare that the moratorium is over. Then you'll be able to raise the rent in 1 year thereafter.
All right, here's on YouTube, Irene. Tenant moved a young man into the house, a foster child, without my knowledge and permission. What is my responsibility? Do I have liability? Do I need to add him to the lease? Thank you.
I don't think there's any requirement to add him to the lease. Generally, a foster child is considered, a dependent child, and there really is no way to prevent someone from bringing in an additional child into the property. Do you have to add him to the lease as an occupant? I mean, you can make a notation to that effect on the lease and have the tenant initial it, but there's no requirement to do so. But there's really little that you can do in terms of preventing a child from joining a tenancy.
If you have something, if you have it written in your lease agreement, can the rent go up $100 or whatever is stipulated in the lease agreement for an additional tenant?
Well, and the issue is in the city of Los Angeles, if your property was under rent control, there's no rent increases. If your property is subject to statewide rent control, again, that's a question that hasn't been decided by the court. Statewide rent control states that you're allowed to raise the rent. And by the way, if your property is subject to statewide rent control, you can raise rents right now, having nothing to do with the pandemic. You're allowed to raise the rent 5% plus the CPI. The CPI for the Los Angeles and Orange County, San Bernardino, and Riverside areas is 3.6%, so you are entitled right now today an 8.6% rent increase. But if you are subject to statewide rent control and your rental agreement states, hey, I can charge an extra $100 if another person moves in, can you do it? And that's a question that really hasn't been decided. You could make the argument that the rent was always the rent plus $100 from day one if an extra person moved in. But I could see many courts stating that, hey, state rent control says that your max is 8.6% currently, 5% plus the CPI, and therefore, notwithstanding the rental agreement, you're not entitled to raise the rent in accordance with the terms of your rental agreement. It's something that is a gray area and hasn't been decided.
Okay, there we go. There you have it. Ginger Gibbs, thank you for your question. Rental is in Chula Vista, San Diego County. Tenant given 15-day notices and returned declarations. Tenant applied for emergency funding but has not provided proof of income. Any recourse for the landlord?
There really is no recourse for the landlord at this point in time. There's certainly no eviction can be brought because he returned the declaration. There's also no basis of bringing forth an eviction because the County Board of Supervisors of San Diego have basically outlawed all evictions at this time unless it's dealing with severe health and safety issues. So if the tenant doesn't comply with the rent relief program, then that's a debt that's owed by the tenant to the landlord. If he doesn't pay the 25%, and assuming we're able to go forward with this, then you'd be able to start an eviction come October 1st. And certainly as to the 75%, you can bring forth a civil lawsuit come November 1.
All right. YouTube, Craig. I had a tenant in Northridge, LA County that moved out in July 2020 and owed about 3 months back rent. He moved to Texas, I think. What should I do to collect? Can I file in California or in Texas?
Just contact the governor of the state of California because he assured us that we'd be able to collect all this rent that he claims was only deferred. But it might fall on deaf ears. And to answer your question seriously, you can sue here. You can serve the person in Texas. If he's out of state, you can actually serve him by certified mail return receipt requested. If he does sign for it, he's considered served. But then how do you collect? You got a California judgment. So how would you collect? And the answer is you'd have to get that judgment enforced in Texas and then try to attach assets. In other words, you're not going to collect on that kind of a case. If he does have money in a bank and he's banking in a national bank like Chase or Bank of America, you could actually attempt to collect the judgment if he has money in a national bank. By the way, ladies and gentlemen, if you owe money and you move out of the state, don't put your money in a national bank because it can still be grabbed. But put it into a local bank, like the Houston local federal credit union, so that someone would have to then enforce the judgment in that. So basically, if a person is moving out of the state, in all likelihood, you're not going to collect in that situation.
All right, thank you, Craig. And Ming Chen, I have applied the rental assistance program, but my tenants do not want to apply. Can I evict them since they don't want to apply? the rental assistance program?
Well, you can by serving that 15-day notice, and if they fail to pay the rent, 25% of the rent. Now, this is for the transition time period. Once again, September 1st, 2020 through September 30th, 2021, for that 13-month period of which he owes you rent, any portion thereof, he'd have to pay 25% by September 30th. If he doesn't apply for the rent relief program, you have the right to bring forth a wonderful unlawful detainer to evict him from the property.
Great. All right, on YouTube, Virginia. Tenants moved out in March, leaving no forwarding address. Can I apply for 100% rent relief? I have no tenants to fill out their parts of the form. They owed $13,000 in rent.
Well, I mean, you certainly should apply. The state will then forward to the tenant either by sending it to the last known address, or I think you have to put, if you have it, the tenant's email address, so they'll be at least attempt by the state to invite them to participate. If the tenant doesn't, then of course it's a debt that's owed to the landlord, which he can then go to small claims court come November 1st.
Right.
Now, the issue is, how are you going to serve that lawsuit? Before filing that lawsuit in small claims court and going through that expense, you want to see if you can locate the tenant. Maybe you know where the tenant works. If you know where the tenant works, then, of course, you can always serve him at his place of employment. If you have no idea where the tenant went, that is going to be part of a program that we're going to be initiating, where as part of the small claims court assistance that we'll be providing come our program in October, we'll check to see if we can find where, through our skip tracing features that we have as debt collectors, we do collect on judgments, to see if we can find out where your tenant moved to.
Yeah, and you guys, I think, I don't have the numbers, but what I hear is you have an effective debt collection service.
Thank you very much. We do.
And so you can definitely contact the H&R Dennis Block and Associates and do that with them. We also, AOA has a debt reporting service where it's going to go on the 3 credit bureaus, and there's debt collection with that as well. Either one, you just got to get it done and hold people accountable. And whether you get it or not, at least it's going to go on their record.
You know, Jeff, I want to interrupt a little bit. Anybody where a tenant owes you rent should be, in addition to try to collect on the judgment, which of course my firm can assist you with, should also be using the services of the Apartment Owners Association by reporting that as a bad debt.
Yeah.
This is a wonderful tool and another reason for joining this association, that you can check that list to find out if your applicant has received a bad credit reporting. It's kind of like a Yelp, where, hey, this guy owed me a bunch of money. Maybe I didn't get a judgment because I just wanted to get rid of this guy out of my life, which happens in so many cases. But why not report that debt that the tenant legitimately owes? And by the way, by reporting the debt, maybe the tenant wants to get out of the auspices of having that on his credit, and he might pay you. So please, not just try to collect the judgment, and of course my firm can assist you, but a very simple, easy thing to do is report that debt to the Apartment Owners Association, and we tell all of our clients to do that.
Great. There you go, guys. Accountability is everything. If we could hold our politicians accountable, I guess every election is when we have a chance to do that. But the more we can hold people accountable, the more they're going to do the right thing. And the more that things are just in the dark, they're gonna run with it. People get away with what they think they can get away with. They try to push the envelope, but if you do report those things, it's going to help the whole industry and the next guy who might get that person as a tenant. All right, we have XJ Investments. I have a no smoking policy. Tenant was smoking weed. How do I get rid of tenant? She is current on rent and lease expires at the end of the year.
Did we state what area the property was located in?
No.
It didn't say anything about rent control or anything?
Nope.
Okay, so difficult to answer that question. Number one, look into your rental agreement and see if there's a no smoking provision within that rental agreement. If there is, then of course we could serve right now, today, notwithstanding the pandemic and the eviction moratorium, we could serve a 3-day notice to perform or quit, giving him 3 days to stop smoking. If he continues, then we have the right to bring forth a standard unlawful detainer action to evict him from the property. If your property is not under any rent control, we can certainly terminate the tenancy right now, today. You're not subject to statewide rent control. You're not subject to a local rent control. And assuming the tenant's on a month-to-month tenancy, we have the right to serve a 60-day notice to quit, assuming the tenant has been there longer than 1 year, or a 30-day notice to quit if the tenant has been there for less than 1 year. If you're under statewide rent control and you're on a month-to-month tenancy and the tenant has lived there less than 1 year, again, we could serve a 30-day notice. We don't need a reason to do so. If your tenant is under rent control and there is no provision in your rental agreement and the person is smoking, what do you do then? Well, I would send that tenant a warning letter that his conduct is constituting a nuisance, which it is. It's bothering other people. And while you can't necessarily tell him not to smoke, you can certainly tell him to smoke in an area where he's not affecting other residents. And if that continues, we can bring forth an action based on nuisance.
There we go. All right, in Everland, California, if a tenant of many years signs a new month-to-month lease, are they considered a new tenant as the date they sign in the eye of a judge?
If they sign a new lease, and I don't know what aspect you're referring to, but generally it's going to be from when they first moved in. So, for example, if you wanted to terminate the tenancy, since they've lived in that unit more than 1 year, even though they just signed a new month-to-month rental agreement last month, you would still have to serve a 60-day notice to vacate, assuming you're not subject to any rent control. So for most purposes, your rental agreement commenced when you moved in, not the date of the new rental agreement.
Okay, great. Deborah Simmons, how does the federal eviction moratorium that expires October 3rd impact California landlords?
I don't think it affects them at all. Some judges and the Supreme Court has said that it can have no effect. Our wonderful president has issued that knowing that they didn't have the right to extend the CDC order, the Centers for Disease Control order. But I don't think it has any effect in the state of California, so evictions can proceed. Some judges were delaying evictions until was July 30th and then September 30th, but again, most judges are proceeding forward.
Great. And then Felix on YouTube, can local moratoriums extend the moratorium past what is stipulated in AB 832?
Sadly, it can, and that's why there's these lawsuits against the mayor of the city of Los Angeles and also against the state of California. For example, the city of Los Angeles' eviction moratorium doesn't have an ending date. The county of LA did, and that's why they have no right to extend their lease, their eviction moratorium beyond September 30th, 2020. So every extension on the county is technically illegal under the state statute. But the city of Los Angeles had it open-ended. So until the mayor declares that the emergency is over, landlords will be forced to go maybe more than 20 months rent without seeing a dime of rent. And this is the same jurisdiction that hasn't really instituted the rent relief program. So they're telling you can't get any rent. They're telling you your rent's deferred from 1 year from when the mayor declares that the emergency is over. There is no time period from when the mayor is going to declare that it's over. And to add salt to the wound, right now you can't apply for the rent relief program. I think it's just a concerted effort on the part of the mayor of the city of Los Angeles to put every income property owner underwater.
That's what it seems like. It doesn't seem like it's hard to think how anyone in their right mind could do what they're doing without there being an evil intent. Okay, NorCal Cosmetics. Just a word for you. If you're in Northern California, a lot of what Dennis Block has talked about today totally applies to you. There's different people asking different questions here. A lot of it's going to be Southern California based. And next week we will have another attorney that's in Northern California practicing there, and he will also share and answer questions as well. And just like as we were talking earlier this morning, Dennis was saying, well, you have this, people will call in and maybe get different answers from different lawyers, even just within his own company. And he would remind people that, hey, well, there's this thing called the Supreme Court, and you get an issue and you end up with judges that are on either side of it. And they're like the elite, right? And so you'll see just different lawyers, different attorneys will have different takes. And so anyway, next week, come and listen to Beckman, and he'll talk about the state, but he'll also talk about stuff that's specific to Oakland, Berkeley, San Francisco, up in Northern California. So, but anyway, if a tenant is Section 8, they should not be moratorium, as their income doesn't change. The HA office evaluate their income regularly if there is any change. What can be done with Section 8 not paying rent?
Again, we don't know what city, and that does affect the answer. If you're in let's say like a statewide rent control area, then if the tenant's not paying their portion of the rent, all you can do is serve a 15-day notice for their portion of the rent, and the tenant would have to sign a declaration under the penalty of perjury that they're financially affected by the pandemic. If he signs it, then, or she signs it, then only 25% of their share is owed come September 30th. There's no way to really, based on the way the statutes are written, to state, hey, you're on a pension or your income hasn't changed, and therefore you have no basis of not paying me the rent and withholding the rent or your portion of the rent.
All right, and Garnick on YouTube, good to hear from you. When can Los Angeles regular rent increases be issued?
If you're under RSO, Rent Stabilization Ordinance, it's going to be 1 year from when the mayor declares that the emergency is over. If you're not under RSO, in fact, if you're just under no rent control whatsoever, then you have the right to raise the rent. Unfortunately, we're limited based on some crazy governor law to 10% as a maximum in any 1 year period, which you would serve a 30-day notice. If your property is subject to statewide rent control in the Southern California area, it's 5% plus the CPI being 3.6%. So right now you could serve an 8.6% 30-day rent increase notice.
All right, on YouTube, Gloud Jr., AB 832 claims 100% arrears covered. Alameda County paid only last 12 months, July 2020 to June 2021, leaving unpaid March, April, May, and June of 2020. Is there any recourse for the balance?
The answer would be yes. You could serve a 15-day notice, and if the tenant doesn't pay 25% and you've applied to the state under the rent relief program, you could then bring forth an unlawful detainer action for that period of time. If the tenant does pay the 25% for that period of time, then your only other avenue is to go to small claims court or regular civil court come November 1st, 2021, and sue there for the 75% that was due for that period of time.
Okay, great. And then someone up in the Northern California area, are there any AOA Bay Area attorneys And just like Dennis Block has an article, he does a Q&A every month that we're so thankful for those of you in Southern California. And up in Northern California, we have Richard Beckman that has a legal Q&A, and that article is featured every month. And so Richard Beckman is one. If you look at the magazine, you should be getting the magazine if you're a member. And in the contractors and vendors page, if you look under evictions, there'll be a list there. And there are several up there for you to choose from. And the same goes in San Diego. We have a different, we have someone else that writes that one. And anyway, so I like to look at all the different magazines because everybody covers different things, and so it's just really informative. If you don't, you can always see all the magazines at aoausa.com. You can go online and look at it there if you're not getting it. But just want to encourage you to sign up. All right. Mary on YouTube. Amen. Scammers and Newsom, let them do it. It's gross abuse. What about the federal government? Aren't they issuing a moratorium too? Okay, so we kind of covered that one, right? So we're going to ignore it basically. And then Ara on YouTube, please answer this question. Concerns all in the city of Los Angeles. If AB 832 ends like you mentioned on September 30th, how would this play out for the city of LA?
Well, we're hoping that the city of LA ends it as of October 1st, and that's what I said, the word hope, because the city of LA is open-ended. So there's really little that can be done if the mayor continues his dictatorial ways of extending this. We're hoping that he comes to his senses. He's now the subject of a lawsuit. If he doesn't, then technically there's no basis of proceeding forward other than to try to get the rent relief program to pay you the missing rent.
All right, here we go. Next one. Okay, Corral K on 10/1/2021. If rent not paid, does 3-day only include only October rent if other amounts are outstanding?
Yes. At that point in time, we have to deal with, quote, the transition time period and the protected time period and civil debt. But it's going to end, we hope, as of October 1st. That means October 1st, the rent for October is due. Serve a 3-day notice on October 2nd for the October rent only. And then we can proceed forward with a standard eviction.
All right, Helen on YouTube. If tenant doesn't pay rent on September and I didn't give them the Form 401 by July 31st, what can I do?
Well, I would certainly give it to them now. Obviously, it doesn't mean that the tenants can live there forever for free because you didn't give some silly form that the governor created. So get the form. It's obviously on the AOA website. And it's no charge whether you're a member or not. That's how great this association is. And just send it now.
Right. Batul on YouTube. Our extra pet now is the reason for eviction. It wasn't allowed before last extension.
You could always evict for pets. You could always evict for extra people. You could always evict for alterations to the premises and nuisance. All of these items you can evict for before and after. The way the code was written was that you couldn't evict for an extra person or for a dog or an alteration if it was related to COVID. Now, Jeff, can you come up with a scenario that you brought a dog in because it was related to COVID? I can't even come up with an example. You could do it on, for example, like an extra person. Let's pretend your kids couldn't go to school, and because of the pandemic, they were home, and therefore you couldn't go to work because you had to watch your kids. Very simple. Therefore, you were out of a job, and therefore you couldn't pay your rent. So if you got someone in to assist you and watch your children, well, in that situation, that would be COVID related. That's the scenario that I came up with, that I brought in the extra person. It's COVID related because I can't go to work because somebody's got to watch my children, and they can't go to school because there is no school at this point in time. But other than that, on what basis can anyone come up with an idea that, gee, because of the COVID, I had to bring in a Great Dane to my apartment? So it's kind of silly. So again, you bring in a dog, anybody wants to call my office, feel free, and we'll start an eviction based on that.
Great, there we go. Okay, Olivia, will you please make sure to differentiate between rent control and non-rent control and how the law affects each type of housing?
Nice open-ended question. Let's see what I can do with that. Generally, you're not under any rent control if you're a single-family home, a townhouse, or a condominium. There are, of course, exceptions, but on those circumstances, you're not under any rent control, which means you don't have to have a reason to evict. If the tenant's on a month-to-month tenancy, you can serve a notice to quit. You can also raise the rent to any level, though the state, through their, quote, emergency act, is saying that our anti-rent gouging statute says you can't go more than 10% in any 1 year period. So, of course, you can always evict the tenant, and you can always get what you want for the next tenant coming in. So I guess the state in that situation is encouraging landlords to evict as opposed to raising rents more than 10%. I guess they didn't think of that one. So that's dealing with non-rent control properties. If your property is subject to statewide rent control, that is, you're not subject to a local rent control ordinance like Santa Monica or San Francisco or Berkeley or West Hollywood, but you're in a city that doesn't have rent control, but you are more than one unit, multiple units, then you would be subject to statewide rent control. Within the first year, you don't need a reason to evict, as we discussed, and why you don't give a 1 year lease. So in that situation, if it's less than a year, you can terminate the tenancy with a 30-day notice. If it's more than a year, you're going to need to have a reason to evict. I said this in our last webinar, that there is a wonderful way to evict tenants that are subject to statewide rent control, where you're not happy with an 8.6% rent increase in Southern California area. You'd really like to raise it more than that, so you would like to have the tenant vacate. There is a reason to evict that everybody can avail themselves of, and that is the renovation eviction. That's going to be available as of October 1st, 2021. If you have a unit that needs renovation, we can ask a tenant that's subject to statewide rent control to vacate on the basis that we're going to do major renovation to that unit. Major renovation means basically that it takes longer than 30 days to complete and requires a building permit, such as an electrical permit or a plumbing permit, where you're going to basically redo the kitchen or redo the bathroom or both. In that situation, we can serve on the tenant a 60-day notice to vacate come October 1st and ask the tenant to leave. We do have to pay relocation money, but the relocation money is only 1 month's rent. So if you're somewhat depressed with rent on a statewide rent control unit, you never raised the rent and now you're stuck because of the statewide rent control, easy way to get around it. We're just going to do renovation, which you'd probably have to do to that unit anyway to get the maximum rent for it. So we can evict the tenant. You must do the renovation, and then we're allowed to raise the rent to market value. So that's basically for no rent control and rent control versus statewide rent control. Obviously, if you're in a a local jurisdiction like Los Angeles or San Francisco, then you're just going to have to comply with that, which means your rent control raises are severely limited. In Los Angeles, it's 0 for 1 year. And you're going to have true good cause, not renovation, true good cause to evict.
All right, Dennis on YouTube. Landlord buys building. Rental agreement states 4 occupants. How can I make the tenant provide me the names of the occupants so I can do an updated rental agreement?
Well, you can't force a tenant to sign a new rental agreement. So if he doesn't want to sign it, then there's nothing you can do. You can't force a tenant to state the names of the people who are there. This should have been given to you by the seller of the property, the previous owner, but sometimes previous owners, and maybe that's the reason why they're selling, don't do their job very well, and they have no idea who's living there. We have clients who buy buildings where the owner doesn't even know what the rent is per month, the previous owner. It's insanity, but it is true. So all you can do is, try to get the information from other tenants or maybe the manager, or maybe take a peek at any mail coming to them to see the names of the occupants. Our firm has a limited way of determining who's living in a particular unit based on our data searches that we can legally do. But again, you can't force a tenant to sign a rental agreement. If your property is not under rent control, then of course you could tell the tenant, hey, sign this or I'm just going to terminate your tenancy.
All right, on Facebook, Darius, thank you for your question. I served a 90-day notice back in December with termination in March. Is that notice stale, and do I have to reserve the notice, or can I move forward with the original notice?
This is a Section 8 tenant, you said?
It doesn't say that. It just says served a 90-day notice back in December with termination in March.
Okay, assuming the tenant is not subject to rent control, then you would have the right to serve that 90-day notice, assuming you haven't taken any rent past the expiration of that 90-day notice. So if the notice expired and you never took rent after, or maybe the tenant never paid your rent after, we have the right now to go forward with that eviction right this second today. So we don't have to wait till October 1st. If you're in a non-rent controlled area and your tenant is on a month-to-month tenancy, we can serve a notice to quit. We can start the eviction. The only parameters that hinder us is that we can't get a judgment in an unlawful detainer action prior to October 1st. So if we start it now, we're not going to get a judgment prior to October 1st. So that case with that 90-day notice, we don't have to wait till October 1st, sir. We just need to start that case right now. Give us a call.
All right, John Coates on YouTube. Are there different methods for an owner-occupied single-family residence with rooms rented out? Evictions, raise rents. Does it make a difference if 1, 2, 3 bedrooms rented out?
Again, I really need to know what area. In the city of Los Angeles, for example, it is totally illegal to rent out rooms. The tenant has no obligation to pay any rent, and the tenant has to be given relocation money to move. If you're in a non-rent controlled area where you rented this house out, which I hope you did, then it is a single family home, so it's still not going to be subject to statewide rent control, and you could terminate the tenancy by just serving a 30 or a 60-day notice to vacate.
All right, here's Joe. I have a tenant in San Gabriel who owes me money for May, July, and August, and May's payment via credit card was charged back. Can we start an eviction immediately since it's unrelated to COVID-19?
You can serve a 15-day notice to pay rent or quit. The tenant's going to have 15 days to do something. The something is either pay the rent in full that's owed, in full, not 25%, but in full that's owed, or sign that declaration under the penalty of perjury that the reason why the rent wasn't paid was due to the pandemic. If you do not get that declaration, if you do not get the rent in full, either of those two things, we have been bringing forth unlawful attainers right now, this moment, to evict those tenants from the property.
All right, thank you. On YouTube, Steve Stern. If a judgment is ruled in your favor, how easy is it to garnish wages or get monies from a bank account?
It's actually really simple. If the guy's working and doesn't quit his job, we have wage garnishments coming. I mean, we get in six figures of collecting on judgments per month in my firm. But the issue is there money in the bank account? Do you know where the bank account is? And where is the tenant working? Did he get up and move someplace else? We have probably the best debt collection software where we can determine where people bank, what their social security number is, and where they're working. And if they are, then we can generally collect, and it's a pretty simple process. But in all fairness, if you're a gardener and you work off the back of your truck and you don't have a bank account, then it's going to be very difficult. You're not going to collect. So that 20 months that the tenant owes you is never going to be seen.
Right, and you should, if you're using the AOA rental application and you're requiring them to fill that out all the way, you're going to have their bank information, and it's going to be a whole lot easier.
Yeah, the only problem, Jeff, would be if they decide to move to a different bank after you filled out that application, or maybe the bank is 100% applicable and there's literally 13 cents in that bank account. When
Right.
we do what we call bank levies, and so we'll send out a writ to the sheriff's office with instructions to do a bank levy, and sometimes we'll hit it for $20,000, $30,000, $50,000. But sometimes we hit it for $1.25 comes back as the amount of money that was in that bank account.
Right. All right, here, Meryl on Facebook. Do these rules also apply for commercial tenants? What is the best strategy to collect from a commercial tenant in Burbank who hasn't paid since April of 2020? He just vacated the property a few days ago.
These rules do not apply to commercial. Commercial has nothing to do with the eviction moratorium under the state laws. You'd have to deal with the local ordinance. The county of Los Angeles has a local ordinance. The city of Los Angeles, for example, has a local ordinance. And there are other municipalities like San Francisco, which I believe has one for commercial. Well, since the tenant is left, nothing prevents you right now, this moment, from bringing forth a civil lawsuit for that rent owed. And certainly our firm could assist you with that.
All right, on YouTube, Monica. When in City of LA, tenants will start paying full rent if still emergency is not lifted by King Garcetti?
For the city of Los Angeles, again, there's nothing you can do if they're not paying the rent. You have to wait for the mayor to declare that the emergency is over. Then the tenant will owe the next month's rent, where you could serve a 3-day notice. All the other rent is deferred for 1 year. Unlike the state where it's changed to a civil debt, you can't ever sue for it. Technically speaking, in the city of Los Angeles, let's pretend the mayor ends it. This is kind of a curious situation. The mayor ends it on October 1st. And the tenant owes you 20 months worth of rent. And that rent is deferred based on the mayor's proclamation for 1 year. So he ends it on October 1st, and you got a smart tenant. So he says, hey, I owe you 20 months rent. Here's my October's rent. So can you start an eviction or you're under rent control? The answer is no, because is any rent owed? No rent's owed. He paid you October's rent. The other 20 months of rent is deferred for 1 year. But the curious part is, here we come, fast forward to October 1st, 2022. And October 1st, 2022, 20 months worth of rent is owed. And it's not considered a civil debt. It's considered rent. And it's not owed more than 1 year ago because it's not due until October 1st, 2022. So on October 2nd, 2022, you could serve a standard 3-day notice for that rent owed for that 20 months and start a standard eviction, because they don't get the protection because they didn't change the definition to civil debt like the state did. So that's the curious part. So circle that on your calendar, everybody, if you have property, at least in the city of Los Angeles and other municipalities that kind of followed the city rule, that on October 2nd, 2022, give that phone number a call, 1-800-77-EVICT, which is my office number. And we'll start a standard eviction on your tenant for all that rent.
All right, let's see. What do we have here? If I reject the rent assistance from tenant, can I still evict? I don't accept the 80% collect. I want the full amount.
Well, again, under the new rules, you're entitled to the full amount, 100%. And under the new rules, you have to accept, if the government offers the 100%, you have to accept the 100% of your money, your tax dollar money, and then that debt would be extinguished. And if the state doesn't pay you or rejects it or doesn't tell you that they're accepting it within 20 days, then you could go forward. But if you get that rent from the state, the 100%, then you can't go forward with an unlawful detainer. In fact, you're required as part of a declaration in that unlawful detainer to state that I have applied for the rent relief program and it has been either rejected or there's been no decision within the first 20 days.
Right, so just apply for it. Housingiskey.com, right? Just apply for it.
Let's do it. Let's see if we can get some money. I doubt it, but let's see.
Yeah, I still don't know if it's 80% of median income or not. I'm kind of under the assumption that it is, but I definitely could be wrong. And let's see, here we are.
I think we have questions for what, the next 3
yeah,
hours?
you know, this is, I mean, it's pretty, there's just a lot of questions. And you guys, you know that there's a lot of questions.
Let's go for another 15 minutes worth of questions. How's that?
Okay, that sounds good. Let me see. Now I kind of lost my place here. Michael, for LA City, did you say that delinquent rent for the covered period is deferred for 1 year? Okay, yes, you already said that, yes. Okay. Grace, can we increase rent in LA City right now if property falls under the statewide rent control?
The answer is dramatically yes, you can, and it would be 8.6%. Go to the AOA website, grab their change of terms of tenancy form, and go serve that 8.6% rent increase on every tenant you got.
Here's a good question from Jill on YouTube. I received state money for 100% of past due rent up to June 2021. Hey, look, they're actually alive and out there. Congratulations, Jill. Renters did not pay rent for July and August. What are my options?
Well, I would wait till September, serve a 15-day notice for the September's rent. Did she say this was Los Angeles under rent control?
LA City, yeah.
Okay, so if she's under rent control, then there's little that you can do at that point. You have to wait 1 year from when the mayor declares that the emergency is over.
Okay, Tom has a question. Why is Dennis so sure the eviction moratorium will end on September 30th?
And I'll tell you why I'm so sure. Stop laughing, Dan. Okay? I don't need no peanut gallery over here. The reason is because they built in to the eviction lawsuit that you have to apply for the rent relief. You can't even file an eviction unless you've applied for the rent relief. So that indicates to me that they're saying, hey, look, we gave you every chance, Mr. Tenant, to either pay the rent, we deferred the rent, and now you're forcing the landlord to apply for the rent relief and that he's going to get his rent. So on that basis, I can't see them extending it beyond October 1st, but anything can happen.
Okay. Okay, there you go. It's a crystal ball, and we will see. And I'm hoping and praying Dennis is right. Okay, I really am. So definitely get involved in the protest and let's make it happen. Right?
Yes, let's make it happen.
Let's make it happen, and it takes activity. And if we just sit back and spectate and only talk, then we are not exercising our rights as American citizens. And freedom is one of these things where if you don't exercise it, it's like a muscle. You actually lose it. You will lose it. All right, boardwalk, real estate. What about the 15-day notice in the city of Santa Monica to get 25%? When is the latest day prior to September 30 that it can be served?
You can serve that right now in the city of Santa Monica, because their statute is now mimicking the state statute. They'll have 15 days, and then they'll have to pay 25%, as I stated, as of September 30th.
All right, Peter, if your tenant has been in the property for less than a year, can you evict them now?
Again, if you're under statewide rent control, the answer is yes. If you're under no rent control, the answer is yes.
All right, let's see.
In that situation, you'd serve a 30-day notice to vacate. Again, the forms on that wonderful AOA website.
Okay, Lisa Welcher, what are the qualifications for the tenants to qualify for the reimbursement?
I'm not sure. The last one was that you had to earn less than 80% of the median income for the county in which the tenant has resided. I'm not sure what the requirements are based on this new program. But again, if they're giving away free money, that money, of course, being your money, definitely apply for it, ladies and gentlemen.
Okay, I'm just kind of going through. I'm looking for ones that have the city stated. So I am skipping over a few of these. I'm kind of searching. And everybody, gosh, please tell us the city and what kind of unit it is. Okay, on Facebook, can we file a civil lawsuit for 100% of the civil debt owed during the transition time period?
No, you can only go for 25. Well, no, I take that back. You can go for 100% of the rent for the civil, on a civil debt once November 1st rolls around.
Okay. Peter, if the tenant's 1-year anniversary expired during the protected period, is he now protected from arbitrary eviction?
One more time on that question, Jeff.
If the tenant's 1-year anniversary expired during the protected period, is he now protected from arbitrary eviction?
I mean, if you have the right to evict and you're in a non-rent control jurisdiction, you can certainly serve a notice to vacate. I'm not sure what you mean by arbitrary eviction. You can't evict for an improper reason. For example, you're discriminating against a certain class of people, but other than that, you can always terminate a month-to-month agreement if you're not subject to any rent control.
All right. On YouTube, can you increase the rent in the city of San Diego?
I'm not sure on the answer to that. I think you're under statewide rent control. I don't know if they have their own statute. In fact, I don't think they do. They don't have their own rent control statute. So I think you're under statewide rent control, and again, you'd be able to raise the rent. I'm believing, but and it's actually on my website, Evict123. If you look at the red banner at the top, I believe for San Diego, the CPI for this year is 4.2%. Add that to the 5, so it would be a 9.2% rent increase. All
right, John Brown, the Sept Supplemental fee has now been mandated. Anything we can do since we're not allowed to collect owed rent? Sept fee.
Not sure what you mean by a supplemental fee.
There's that. I think it's a per unit.
Are we talking about like the city of Los Angeles?
Yeah, maybe it's.
I'm not
Santa
sure what he
Monica,
means by that
the
question.
SCEP supplemental fee.
Oh, okay. Well, that's the special code enforcement program, but that's. Can you collect that? Well, the tenant owes that. That is part of the standard rent. But again, if the tenant is claiming COVID, then he doesn't have to pay it and it's deferred.
All right. Is there a rent freeze in Lawndale and Hermosa Beach?
Okay, both of those jurisdictions do not have local rent control. If you're talking about multiple units, either a duplex or higher, then you're under statewide rent control. And again, you're limited to 8.6% for those areas in LA County. If it's a single family home, then there is no limitation except for the quote anti-gouging provision, which is still on the books for some crazy reason. And you can't go above 10%.
All right, Virginia, for the city of LA, can you evict if there is unauthorized person in the unit? Just received supplemental tax bill code from code enforcement, HCIDLA, another assault on landlords.
That is another assault on landlords. The Housing Community and Investment Department. Well, why did they get that name? It's an anti-investment department is what it really is. But yeah, we can go forward on unauthorized persons even though we get letters from the inspectors from, it's called the HCID, the Housing Community and Investment Department, that says we can't do it, and we ignore those letters and we just go forward and we do evictions on unauthorized occupants.
All right, Lee Sally on YouTube. Los Angeles, under rent control. Can I charge tenants now for smoke detectors, cost recovery, and RSO fees? Yeah,
I mean, these are fees that are owed under the rent stabilization ordinance. The tenant owes it, but if the tenant's not paying rent, then because of COVID, then that rent is deferred, be it the small fees and the main rent. It's deferred for 1 year.
Okay. Ellis Act evictions, are Ellis Act evictions okay in Long Beach?
And the answer to that is you can do an Ellis Act eviction. You are going to have to wait until, by the way, Ellis Act eviction, for those people who don't know what that is, it's a permanent removal of rental housing from the rental housing market. So, for example, you have a duplex and you would love to just tear it down and build 6 condominiums with subterranean parking, and the duplex is occupied. You would be able to serve termination notices on the tenant, even though that unit is subject to statewide rent control. You have to pay relocation money. That relocation money is 1 month's rent, but you have to wait until October 1st, when my prediction that the statute will be over at that point.
Okay, Frame LA, can we ask new tenants for proof that they have been paying rent for the past year?
And the answer is the mayor has not set up any requirement that the tenant show proof of anything. So it doesn't matter that the guy's a pensioner and never lost his job. They don't have to show proof of anything. In that case that I keep referring to from my client that just started a case yesterday, where the tenant has $400,000 in a bank account, they don't have to show proof of anything.
They're talking about, Dennis, they're talking about when they're looking at different applicants, are they able to ask if they've paid rent for the last year. Ask for
They're
proof of
talking
it.
about applicants?
Right,
for new
yeah, so they're screening different applicants.
Yeah, I think you can, certainly is a fair statement to show proof that you've paid, sure. But I don't think you can use that failure to pay due to COVID as a reason to reject the applicant.
Right, yeah. Okay, Evergrove. If a tenant does not qualify for the Rent Relief Act, would that help a landlord win a civil lawsuit in small claims court?
Well, then you're going to have to do a civil lawsuit. So either you can start an eviction based on the 25% that's owed for the transition time period. That's a straight standard eviction come October 1, or wait till November 1 and sue as a civil debt for all the money or all the rest of the money. So you could actually bring forth an unlawful detainer and also a civil lawsuit concurrently.
Okay, we have a couple different people with questions about when they can apply for the rent relief program. And so that, yeah, could you just tell us, are there any places where it's closed that you're aware of?
I'm aware that it's closed in the city of Los Angeles, so keep checking back. But otherwise, just apply and let them tell you that it's not open at this time.
Right, and you would apply even if you're in the city of LA, since the LA one is closed, you would apply for the state one.
Yeah,
wouldn't you?
I've applied for, we have buildings in West Hollywood. Those, we actually saw some money come back through our management company, and also one property that I own in Studio City. That property, we have a tenant who's not paying rent, Dennis Block, believe it or not. And that person we applied, but the city is saying that it's not applicable at this time, that they're closed. Closed. What else do you got to do, Los Angeles? You can't open up this program?
Yeah.
So we're going to keep applying come next month.
All right. Well, hey, it's 11:45, and I got to make you a my famous blueberry shake for lunch.
Oh, thank you.
So maybe you can stick around for that. But anyway, there are so many questions, everyone. There are just so many questions. You can call Dennis Block's office there. You see that number 1-800-77-EVICT. He's serving Southern California. If you're up in Northern California, definitely go to the AOAUSA.com website and just search in the contractors and vendors, and you'll see a bunch of different attorneys that pop up there. Or look in your magazine if you're a member and you're getting the magazine. Take a look at that. Don't forget, 1 o'clock today, we're going to have somebody come and share about how you can get the most out of your insurance claims and limit your liability. So that's something that it's good to know it, and then you just have it in case something happens, and fire season will come upon us. And so that is specifically about smoke damage, and so that'll be a good one. Last week was ADA compliance with a guy that has over 36 years experience. You'll want to look at that one. Subscribe and join our email list. You'll get updates on different live streams that we're doing, different things that are happening. If there's a specific city where we need to rally and do something politically, then you'll be informed about that as well. And of course, we want you to join AOA, and so you can call in and get questions answered. And anyway, Dennis, thank you so much for taking time to be with us. And do you have any parting thoughts for us?
I do. I'm guessing that we're going to revisit this webinar towards the end of September, when maybe the program will be over and everybody will be itching to move forward with getting back their units and actually seeing some rent money. So once again, I appreciate the opportunity with the Apartment Owners Association to put on these webinars. I really do believe that we all get a wealth of information, not just from this one, but all the live streams that the association puts forward. And, I tip my hat to them for educating all the members. And Jeff, Dan, thank you very much.
All right. So thank you, everyone, again. Let's just go for it politically. Let's let people know that, hey, you know what? landlords are people, and we should not be discriminated against, just like anyone else, and that this eviction moratorium is really a joke, and there's better ways to do it. So get out there, be politically active. We'll see you at 1 o'clock or next week if you show up then. Thanks again, everyone. Bye-bye.